Other comments with respect to what constitutes, I'm going to use a term, a generic term, the right of someone to take a cell phone and look at its contents? Reno, Elko, Carson City, do you wish to respond? Dr. Lee, here in Las Vegas.
As administrators in schools, we take the position of being the parent to the children. And so, like, for example, parents that suspect that their child might be having some drug issues or something like that, they go in and search the room. And that is part of what we try to do, to try and solve some of those issues. Well, now with sexting and all the many things that go on with our cell phones, we do some of those kinds of things. When we feel that there's a reason that if there's a child that may be in danger, or the safety or the security of the other children at school, we act as if parents. And so we step up, and that's when we do those kinds of things. It's a little bit different than the police and the court system.
Other panels, Elko, Reno, Carson, do your panel members wish to respond or comment on the PC probable cause issue relating to reviewing matters on someone's cell phone that's left behind? Very well. At this point, I also have another question. I'm not sure that anyone's picked it up on their go-to-meeting question. Another question is, texting with suggestive words but without suggestive pictures, is that or is that not sexting? I think we came close to answering that before. Are words alone enough under our laws?
I have the law in front of me. And it actually defines a performance as a play, film, photograph, computer-generated image, electronic representation, dance, or other visual presentation that would appear to limit it to visual depictions. But that said, being prosecuted versus being administratively disciplined are very different concepts. And so where you may not be able to be prosecuted for sending a lurid text, you may be able to be administratively disciplined within the school district.
And I can just add that one of the things that some of these impulsive kids don't realize is if you get expelled, you don't go back to your high school. You don't get to participate in the football games. You don't get to be a cheerleader. You don't get to do those things. And a lot of times, because of the impulse, they don't realize it limits a lot of their future.
The good, the bad of technology.
That's right.
I had one more thing I wanted to add, which is also an exchange of emails between a boyfriend and a girlfriend is one thing, but there are also offenses referred to as luring, and that's another statute you could potentially get yourself hung up on, is luring a child. So that could be just a text and not an image.
Ms. Roski, I believe you wanted to comment.
I believe Ms. Brown covered it. I just wanted to point out that it would require a visual image. Thank you.
Very well. Judge Steinheimer, I understand that there's a question pending in your venue. At least that's what my technology is telling me.
We do have a comment in Elko.
Judge Simon, are you wishing to comment in Elko?
I believe Officer Christy Stake has a comment.
This is just a comment in
Our
regarding
first
to the
technological difficulty that we've encountered. Hold on a second. We're not getting sound from Elko.
Can you hear me now?
Judge Simon, can you hear us?
We can hear you just fine. You know.
We're having a problem with your volume. We've got our tech. Would you speak again, Judge Simon?
Oh, can you hear us now?
Yes, Christy, we can hear you.
Okay.
Did you have a question or a comment?
No, I just had a comment regarding whether or not words were considered sexting. Now, I just wanted to make a comment to all the teenagers that are watching or listening to this. By law, I don't think there's anything that can be prosecuted for words. However, the juveniles just really need to remember that when they're sending out these graphic descriptions of what they are doing or going to do or want to do, we need to know do you want that information passed out to everybody else, because it is sent? And so although sexting, I think it can be considered sexting, it's not against the law. However, the juveniles just really need to remember that that is something that can be disseminated to everybody else that wants to see it, or they want to pass it out to. That's it.
Thank you, Christy. Mr. West, did you wish to make a comment?
I was just going to comment on, I think the difference too is that when it's words, are they words that are welcome? Is it an exchange between a boyfriend and a girlfriend words versus is this something that kind of goes back to our previous topic of bullying, something where you would send an email or a text message saying something you want to do to somebody who may not be willing or want to be part of that, then that would obviously cross the line of harassment and targeting somebody in almost the same sense as bullying, with picture or not.
Judge Steinhammer, I'm told that you have a general question.
No, but I'm glad to ask my panel members to address the general question of just sexting overall and how large of a problem is it here in Washoe County, and do we need to find other ways of dealing with it, or are we dealing with it appropriately? Maybe Frank Cervantes from Probation Department can tell us and start there. How big of a problem is it?
It goes back to my earlier answer on it's not identified as a major problem. We don't get a lot of offenses. We get some charged. Sometimes they come across as harassments or something other than a sexting. But quite confident it's prevalent in the community, in the school system, and among our teenagers.
And Ms. Sullivan, what are you seeing in terms of your defense of both this kind of charge that may come out of it, or dealing with the juveniles you deal with on that personal level with the sexting issues?
Talking to kids on a personal level, sometimes what we'll have is the boyfriend and girlfriend relationship that has soured. And certainly text may be a part of that, and they may not be prosecuted for the text, but it may be harassment or things of that nature that do involve some sexual talk that's been going back and forth or communicated over the phone through Twitters or on Facebook. And we also see instances in the schools, I think, where in discipline records that were sent to review, if a child is coming to my office, perhaps even on an unrelated case, I'll still see discipline records. And the prosecutors and the judges are going to have a chance to review these discipline records too, which may contain instances of sexting and behavior like that, which can then be taken into consideration when these juveniles appear in court for perhaps other offenses as well.
And Judge Higgins, when we were listening to some of the other comments made by the other panels across the state, you commented on some things that you're seeing in sex cases that maybe isn't a depiction, but is words that rise to a level of a different crime. I think you talked about luring.
Oh, there is a luring statute in Nevada that if an adult, and I think it's over the age of 21, uses the internet to convince a child, for instance, to leave the house or meet them for a date, it's a felony. And these arose out of the online relationships where a teenager thought they're talking to another teenager, and an airplane ticket gets sent, and they go to Iowa, and it turns out it's not a 15-year-old, but a 50-year-old that has convinced them and lured them out of the house. So Nevada has a statute that says if somebody is taking out of parental control through the use of the internet or any similar technology, it is a crime. And if they're convinced to leave the house and then end up being involved in child pornography, for instance, it enhances the offense. So Nevada has a statute that addresses that use. There is an exception in the statute if the age of the participants is close together. So if the 17-year-old sends his 16-year-old girlfriend an email that says, let's meet for dinner or sneak out of the house, that's not a felony. But if there's an age difference, it is.